All right, I'm going to kick us off. There are others joining as we see folks joining, but I'm going to go ahead and kick us off and let everybody join us as they do. We are delighted to have you here. Thank you for joining us for today's webinar addressing what's next in children's privacy. We're going to have an update from a real expert in the topic on the FTC's proposed changes to the COPPA Rule. I'm Lisa Sotto. I chair Hunton's global privacy and cybersecurity practice. And in today's program, Phyllis Marcus will discuss the FTC's recent proposal to strengthen federal protections in children's privacy, as well as the implications of the new changes for businesses. Before we begin, I'd like to just announce a couple of logistics. If you have questions throughout the program, please use the Q&A feature on your screen. It should be at the bottom, and type your questions in there. And if we have time, we will address them at the end of the program. A PDF copy of today's deck will be available in the chat feature. You can find it there now. So if you'd like, please download a copy for yourself. And the program is also being recorded, so just so you're aware. So now I'd like to introduce my colleague, Phyllis Marcus. Phyllis is a partner in the firm's Washington, D.C. office. She is recognized in the Legal 500 United States. She was at the FTC for 17 years, and her experience there provides a unique combination of expertise in privacy, in advertising, and in marketing law. Phyllis counsels clients on compliance with the COPPA Rule and also on managing related enforcement actions. And prior to joining Hunton, now a decade ago, I believe, Phyllis was the FTC's Chief of Staff for Advertising Practices and leader of the FTC's Children's Privacy Enforcement Program. She's also the author of the chapter on the development of U.S. children's privacy law for IAPP's treatise on children's privacy and safety. With that, I'll turn it over to you, Phyllis.
Thank you so much, Lisa, and good morning, everybody. I'm thrilled to be spending the next hour with you. And on the screen, you can see what our roadmap is for the coming hour. I urge you to stick with us. Your reward will be a lot of learning, and at a certain point down the road, also a code for the CLE credit that you'll receive for participating today. First, we're going to talk about the Children's Online Privacy Protection Rule. It's known as COPPA, and give a little bit of background where it came from before we can talk about where we're going. Then we'll provide a detailed overview of the FTC's COPPA proposal, which was issued in the third week of December in 2023, so just at the end of last year. Go over some implications for organizations, and then talk about what you can do if you have feelings about this proposal, and where to submit formal comments for them. So let's get started. So what is COPPA? Most of you, I would assume, because you're here, know a bit about it, but it's very interesting to start with its genesis, which was, believe it or not, in 1998. Worried about both the spread of collection of personal information from children online and treating kids as entrees into households, and also the ability or the potential ability for strangers to contact and connect with children online, Congress enacted the Children's Online Privacy Protection Act. And I like to say this was the fastest thing that Congress ever did. There were hearings and an FTC report in the summer of 1998. And by October, the legislation had come into being. Senator Bryan and Senator Markey were the sponsors. And interestingly, Senator Markey is still at it. He has a COPPA 2.0 proposal that we will talk about a little bit, but I'm thinking that would be a wonderful topic for another webinar. There's just a lot going on in children's privacy these days at the federal level, at the agency level, at the state level, and certainly internationally. COPPA is by statute primarily enforced by the Federal Trade Commission and can be enforced by the states and certain other federal agencies. The FTC has been the most active as the enforcer, but there are these opportunities for other enforcers around the ecosystem to play a role too. Key to this federal statute is that it defines a covered child as someone who is under age 13. And that has become a bit of a sticking point, especially in today's climate, where there's grave concern about the protection of teens as well. But COPPA covers children who are under the age of 13, doesn't cover teenagers. Although that could change with the COPPA 2.0 proposal, which would define a child and a teen and cover a teen under age 17. And COPPA covers sites and services, so a whole range of online services. Apps were only a glimmer in someone's eye in 1998, but the statute was written broadly enough to cover online services as they developed. And it covers those sites and services that are either directed to children under age 13 based on a weighing and a consideration of a variety of factors that would make something directed to children, or those sites and services that have actual knowledge that they're collecting personal information from children under 13. So there is this dichotomy, kind of a binary. On one side, you have sites and services that are directed to children, and on the other, what we call general audience sites and services that would only be covered if they have actual knowledge. Now, that becomes a key issue in the FTC's rule review as well. By statute, the knowledge standard is set. It would change under COPPA 2.0, and the FTC has said a bit about their inability to change this knowledge standard during the pending rule review, the one that's ongoing. And COPPA doesn't prohibit activities directed to children. It does require notice and parental consent, but there are substantive obligations on treatment of children's personal information once collected. So here are the 10 things that COPPA provides in terms of substantive protections or obligations for operators. And we won't go over these, but I will linger on this slide for 1 minute to say that COPPA is a notice and consent statute, but it's notice and consent plus. And, let's see, notice and consent are items 1 through 3 on this slide. So we've got 8 other substantive obligations. Notice and consent has gotten a bit of a bad rep, but that's the way the statute was structured. And then you have these other obligations that operators must comply with in order to be fully compliant with COPPA. So it's key before we go on and talk about what the FTC is proposing to understand what identifiers currently are covered by COPPA. And this list got a little bit longer in 2013. Under statute, Congress gave the FTC the right to enact regulations, which the FTC did, and those went live in the year 2000. And those regulations make up what we call the COPPA Rule. So we have the statute, and then we have the FTC's COPPA Rule. And within the statute, Congress permitted the FTC to expand the list of personal information to include other identifiers that the FTC, in its assessment, deemed permitted the online or physical contacting of a child. We won't go into how the agency weighed each identifier that it added to this list, but they did have to go through this balancing test of whether the identifier permits the online or offline contacting of a child. And so this list was expanded in 2013 to include items like a persistent identifier that can be used to recognize a user over time and across different sites or services, geolocation information such that it's sufficient to identify a street name and the name of a city or town, and photographs, videos, or audio files that contain a child's voice or image. So this list that you see on the screen now is the current list of items that the FTC deems to be personal information for which, with limited exceptions, an operator would need to notify parents and obtain their parental consent prior to collecting, maintaining, using, or disclosing. The FTC is proposing to expand this list a bit in the current rule review that it is had engaged in. So here is the timeline of a bit of what I've said and where we are right now. So we start in 1998 with the enactment of the statute. In 2000, the COPPA Rule went into effect after a rule-making initiative that the FTC engaged in. And we fast forward a bit to the years 2010 through 2012, where the FTC conducted a voluntary rule review. The FTC is generally on a 10-year cadence to review its rules, and those are on a voluntary basis, but it was determined that enough technological developments had occurred between the years 2000 and 2010 that a rule review was merited. In 2013, after taking comment, after holding a workshop, after issuing a revised proposed rule and then a supplemental, the FTC issues a final rule, went into effect in July of 2013. And that was known as the upgraded rule, the revised new rule. And then we move ahead 6 years, and the FTC announces what it was calling an expedited rule review. So if we were looking at a 10-year cadence, we would have hit the next voluntary rule review in 2023, but the FTC had determined that enough developments had taken place in the intervening 6 years that an expedited rule review was warranted. And then we come to a bit of a halt. The FTC issued a questionnaire in 2019 posing general open-ended questions about the rule's utility and its costs and benefits for operators and for parents and children, and received a slew of comments. Something like 175,000 comments were submitted. Many of those were form comments submitted by content creators on YouTube. And the FTC's rule review was paired with, or just slightly followed, or may have preceded by a week, the FTC's announcement of a law enforcement action against YouTube and Google. And that garnered and prompted a whole bunch of comments. And then 4 years passed, and we hit December of 2023 when the FTC issues a revised proposed COPPA rule. And that is where we are right now. In 2019, when the FTC issued its questionnaire, it did not have proposed language to suggest to the public. It was not, it wasn't the same as what the FTC did ultimately in December. This was, as I said, a more open-ended questionnaire, and these were, on this screen, you can see some of the questions that the FTC was asking about the way the COPPA rule functioned. They did raise questions about some new technologies, interactive TV, interactive gaming, other similar interactive media. They asked questions surrounding ed tech and its use in schools and how operators were to engage with schools when ed tech was deployed in the classroom. And particular questions relating to encouraging general audience platforms to identify and help police on their own child-directed content that was uploaded by third parties. And this, as I said, prompted something like 175,000 comments, and the FTC thought about those comments and the direction it wanted to go for 4 years, and then issued a proposed revised COPPA rule. So here we're going to start digging into what the FTC's current proposal is. And I'll say I read it so you don't have to, but I am sure that tons of listeners on this webinar yourselves read the FTC's proposal. It was incredibly lengthy. The agency indicated that they intend to modify most of the rule. But very interestingly, the front end of the FTC's proposal talks about what won't be changing. And I think it's worth our spending a little bit of time talking about what the FTC will not change and why. Because the FTC's explanation is quite fulsome and intended both to, I think, flag to Congress where parts of the agency is constrained and may not have the authority to make changes absent a statutory change, and in some ways to reflect the overwhelming sweep of changes that have occurred in the children's privacy and safety arenas since COPPA was enacted, since the FTC opened its rule review in 2019, and prior to the time the FTC issued its revised proposal in 2023. So much of this will seem familiar to our listeners because these concepts have started to take shape and be incorporated at least at the state level and in fact at the federal level with some proposals. The first is that the FTC indicated that it is not going to be expanding the concept of directed to children to include sites and services that are likely to attract children. And that likely to attract standard comes from the age appropriate design code enacted in the UK, also adopted by California under the California age appropriate design code, and considered in concepts at the federal level too. Now, why is this important? COPPA has long contained, as I said, a multitude of factors that operators can use to direct, shape, and design their own sites and services, and that the FTC will use to consider whether a site or a service is directed to kids. And they are somewhat in opposition to a likely to attract standard. We have things like the language used, the animation, the colors, whether the operator has incorporated models or celebrities or music that appeal to children. These are more concrete, intentional incorporations of elements that can put you in the directed to children bucket or not. Now, there is another part of the directed to children standard that gets us a little bit closer to likely to attract, which is that the FTC also will consider competent and reliable empirical evidence of an audience composition of a site or service, so that if you end up having a lot of children there based on competent and reliable evidence of your participants, you may be deemed to be directed to children in any event. Now, the FTC has long said no one factor is to be weighed over others, and that you kind of put everything in the hopper and see what comes out. But the agency has drawn a line and said even competent and reliable evidence of audience composition is not the same as likely to attract. And they are retaining the directed to children versus general audience division that was intended by statute. The FTC also said that they will not shift from actual knowledge to a constructive knowledge standard, that they are in fact constrained by statute from doing so. The agency articulated this same limitation in the 2013 rule review. And perhaps reiterating it here was intended to flag for the public that this change can only come by a change in the underlying statute. And in fact, the COPPA 2.0 legislative proposal does change the knowledge standard to one of constructive knowledge, but the FTC itself cannot make that change. And then kind of getting into the weeds, the agency also said that it's not going to greatly expand the definition of personal information to include data that is inferred about a child. By statute, the entire regime of COPPA is intended to apply to personal information collected from a child. It is not intended to cover personal information about a child that may have been uploaded, for example, by a parent or someone else. And so the FTC spends a little bit of time talking about the fact that it will not expand the definition of personal information to include data inferred about a child, nor will it reverse its decision made in 2013 to limit the way the COPPA regulation treats persistent identifiers. This I found a little curious because I had thought that this issue was fully settled. That is, that once COPPA was expanded to include persistent identifiers in 2013, things had been settled, but the FTC felt the need to reiterate that it wasn't going back. It wasn't going to require persistent identifiers to be associated with other concrete items of personal information in order to itself be considered personal. And then the FTC said that they were not going to significantly narrow or expand the what is known as the support for internal operations exception. And COPPA really, it needs to be considered kind of as a whole. So in its expansion of the definition of personal information, that could have been a massive blow for operators logistically and compliance-wise, but the rule was expanded also to allow particular use cases for the collection of persistent identifiers, and that's known as the support for internal operations exception. Now, the FTC said that they're not going to significantly narrow or expand that exception, but they did, and we'll talk about how in the slides to come. So here you have the 12 changes that the FTC is proposing in the revised proposed COPPA rule. And there's quite a bit of meat here. We're going to spend some time talking about some of these, but not all of them. But you will get the slides. I believe they've been uploaded to the chat. And so you will have all of this information to take away with you. And we could spend other sessions talking about EdTech and oversight of the safe harbors, but we're primarily going to focus on the items contained in numbers 1 through 10 on this slide. So we're going in a bit of chronological order because that's the way my mind is ordered and the way I think of COPPA. So the first is to think about what the FTC is proposing with respect to the definition of personal information, because everything starts from that. If you're an operator who has to comply, you want to know what it is that I can and can't collect before having to consider my notice and consent obligations and all of my data retention and sharing obligations as well. So one is actually a bit of a gift. That is that the FTC is expanding the definition of online contact information to include mobile phone number. And this proposal is intended to facilitate communications with a parent for the process of obtaining parental consent. This had been considered in 2013. For technical reasons, the agency rejected this proposal at the time. They've revisited it and are proposing to include mobile phone number as online contact information. I'm going to pause here for 1 sec to cough and to take a sip of water. I will be right back. Thank you. Okay, we're back. So I think a lot of the listeners will think that mobile phone number inclusion is a good expansion, and whether we care whether it's in the definition of online contact information or not, probably not. But anything that makes notice and consent easier, I think, will probably be a welcome change. Some of the other areas that the FTC proposes to include, perhaps maybe a little bit more complicated. It should come as no surprise that the FTC was looking to expand COPPA to include some version of biometric identifier. On the screen, you see the definition that the FTC has proposed. This may or may not hold. It is a very expansive definition and excuse me, and includes data derived from other data. And I think that piece of the definition might be some cause for concern among operators who would have to comply with COPPA. But I think we shouldn't be surprised, given the developments of technology, that the FTC is looking to use COPPA as a launching point to regulate the collection of biometric identifiers, especially when it comes to children. The FTC had, in 2017, announced an exception for the collection of audio files when they substituted for a text chat. They're going to expand that just a little bit and accept the collection of audio files used to respond to a request from a child if those files are immediately deleted. And the FTC has been very clear to say those files cannot be used for product improvement or internal operations, even if an operator takes steps to de-identify the data. So I would expect that this proposal, especially as narrowly presented, may be one that our listeners want to consider when you're thinking through the application of COPPA to your activities, or whether you want to comment to the FTC on its proposal. And then there are a couple of other items that the FTC has proposed, avatars being among them, and also usernames that don't permit the contacting of a child across sites. And this one I find a little curious, but the FTC is concerned that if a child uses the same username over and over again across a body of sites and services, they could be more readily contacted just by virtue of that reuse. The other thing that, okay, so those were the expansions of the definition of personal information. And I will pause to say, the FTC is taking comment on its entire proposal. We'll talk about that in next steps. But as you're listening here, maybe think through whether there are things that really catch your eye that you might want to comment on back to the agency. I know from personal experience that those comments are read, those comments are considered. The more concrete the language you can provide, the better. So start taking notes. The FTC is also thinking through expanding the factors that it will consider in the directed to children weighing that we talked about just a couple of minutes ago. It's doing so in a slightly odd way. It is proposing to add some additional indicia to this concept of evidence of audience composition. Marketing or promotional materials or plans will be taken into account. What the operator says to third parties or consumers about its own site or service. And then I know the next two are things that are of significant concern to people. The reviews of the site or service by users and third parties. So these are, this is commentary external to the operator's own experience and somewhat out of the operator's control. I'm in the age of users on similar websites or services. And then the FTC has proposed what we're calling a safe harbor for audience composition analysis. And this is because you don't have an obligation now under COPPA to go out and figure out who is on your site or service, but there is a concept that it might aid everybody in the online community to know more about who's on your website so that you can provide protections to children who are covered by COPPA. The FTC has asked an open-ended question about whether it could promote this composition analysis if it were to say that if after you've done your analysis, you end up seeing that X percentage of your kids or no more than X percentage of your users are kids, then you won't be deemed to be directed to kids. We'll see where this goes, but right now it's in full exploration mode. When I said that the FTC said that it wasn't going to narrow or expand support for internal operations, it's not entirely true, despite the FTC having said this. Support for internal operations is a key exception that many of you, I'm sure, rely on to engage with children online when you take from them only persistent identifiers and no other items of personal information. And these are used to make your website or service run, to perform analytics, to run fraud or theft or safety controls, and to personalize users' experiences. And what the FTC is proposing here, and I see that this has been woven back into the COPPA 2.0 proposal that was released last week, is that there are certain things you cannot do and claim that they're support for internal operations. You cannot use those persistent identifiers to amass a profile on a child. You cannot use them to deliver behaviorally targeted advertising to a child. And the FTC is proposing that you cannot use those persistent identifiers in connection with processes that encourage or prompt the use of a website or online service. This is the nudge technique, or the do not nudge technique provision. The FTC has expanded this a bit in its discussion to talk about operators not being permitted to use push notifications to try to draw a user back into a website. They talk about maximizing engagement. They talk a bit about screen time concerns. And so the FTC is weaving in here some of what we see in the age-appropriate design code context, but doing so in the way they can. Again, remember I said they're constrained in many ways by the underlying statute. And so they have incorporated an anti-nudge technique provision in the prohibition on support for internal operations. If it sounds complicated, it's because it is complicated. And I expect that there will be a lot of commentary here. The FTC, in a bit of a surprise move, at the back end of this very long document, included 20 questions, open-ended questions, some of which reflected changes that they made in the front end of the document and are proposing to revise the rule with. Some of them were just additional questions, like, should we change the current protection for the delivery of contextual advertising, given the sophistication of the advertising industry overall? And I assume a lot of listeners on this webinar will have a lot to say about retaining contextual advertising for the children, and if COPPA 2.0 goes into effect for the children and teen environments. Then moving on, as I said, COPPA is a notice and consent statute in part, and the FTC is proposing to alter the information that is included both in the direct notices that go to a parent prior to a parent manifesting their consent to a child's engagement in the site or service, and also in the online privacy policy. And in the questionnaire that the FTC has included, they're asking whether some of this information is better posed in the privacy policy versus in the direct notice. But there are some significant expansions in these notice documents. One huge expansion that we'll talk about a little bit more when we get to consent on the next slide is that the FTC is proposing a separate verifiable parental consent for disclosures of children's personal information. This would be a second level of consent, and you need to tell parents about this right and feature in your direct notice to parents. You also have to tell parents how you use children's personal information, including if you use persistent identifiers or other identifiers to deliver push notifications. Then in the privacy policy, this is a very interesting expansion. You will have to specify, or operators will have to specify, how they use persistent identifiers and describe to the public and parents how the operator complies with COPPA's limitations in this regard. That is, how the operator does not use the persistent identifiers to serve behaviorally targeted advertising, amass a profile on children, or nudge them. And the FTC is also proposing for the first time that operators have a written children's data retention policy, and that has to be provided in the upgraded privacy policy. With respect to consent, there's some good news and there's some other news, the FTC is proposing eliminating the requirement of a monetary charge in connection with use of a payment card as a form of parental consent. And it's folding into the COPPA rule mechanisms that it has recognized in a separate process as being valid forms of verifiable parental consent. And the big one, as I said before, is that the FTC is proposing a new separate verifiable consent for disclosures, and has said very concretely that operators may not condition access to a site or service on the parent providing or not providing that consent unless the whole nature of your site or service is to disclose information. And it's proposed a bunch of questions relating to this separate verifiable consent. What types of activities are integral in disclosures, and what might not be. So there's a lot to dig into there. The FTC has also asked in its questionnaire what role platform-based consent might play. This was considered in 2013 as well, really without answer. And the FTC is asking again to see if there's any more concrete discussion that it might be able to use to propose forms of platform-based consent. So we'll have to see what develops there. Then we get into the substantive obligations and rights that I talked about at the very beginning of the webinar. The FTC is proposing that operators develop a children's data security program, and the requirements of this program are modeled on the Gramm-Leach-Bliley rules. And here you see on the screen the components that would be required in this updated and separate, arguably a separate plan. The plan has to designate a coordinating employee. Assessments to identify risks have to be performed at least annually. Safeguards have to be developed to identify risks. Those safeguards have to be tested and monitored to determine their effectiveness. And the whole program has to be evaluated and, where appropriate, modified at least annually. And if the operator is releasing information to third parties or to other operators, they have to get assurances in writing. That's a bit of an upgrade from the assurances requirement that was contained in the 2013 rule. So we expect that there's going to be a lot of comment on this requirement, maybe some thoughts about whether, if you as an operator already have a robust data security program that takes children's information into consideration, whether you also need to have a separate one. Open questions. On data retention and deletion, COPPA has long held components of reasonable retention, secure deletion, but the agency is proposing to beef up this provision as well. You have to have a written data retention policy specifying why you collect children's personal information, the business need for retaining it, and your time frame for deleting it. You may not retain children's personal information indefinitely. The FTC says this numerous times in its proposal. So this is a new component. I think it will give people a lot of thought about the burdens of doing this, unless you already do this for user information. And it's easy to beef up your schedules. Again, though, you will have to post your children's data retention and deletion policy online in connection with your privacy policy, which is a new component of all of this. Then moving on to EdTech, you may recall that the FTC has long exempted the use of EdTech in school settings from the parental notice and consent scheme. This was done by guidance. It was actually hinted at and discussed way back when, in 1999, when the FTC issued its statement of basis and purpose for issuing the initial COPPA rule. And it has been retained, codified, but not officially in FAQs and guidance the FTC has issued. A couple of years ago now, let's say maybe 6 or 7 years ago, the FTC had a workshop where it considered what to do and whether it should make more formal all of its guidance relating to EdTech. That workshop was held in connection with the Department of Education. And the question was whether to conform COPPA to FERPA, whether it served a different purpose, whether to incorporate the longstanding practices into the rule. And in the current rule review process, the agency has determined that yes, it will formalize its advice and guidance regarding the use of EdTech in schools. It will make it easier for EdTech vendors. The right to review and have deleted children's personal information is given to the school now, not to parents. There are very tight strictures that the agency is proposing with respect to the kinds of services and the kinds of data uses that educational institutions and EdTech providers have to comply with in order to, and remember this is an exception to parental consent and notice. So there are new notices that have to be posted on the EdTech provider's website and given to schools. There are limitations on the use of the information collected. It has to be solely for the educational service for which it was launched. And while children's personal information can be used for limited product improvement and development, that is really limited, and it cannot be used for other services. So you can't collect it for one educational service to develop or improve a different service. You cannot use children's personal information for marketing purposes. Here, I'd like to pause, take a deep breath, and Lisa, if you are monitoring the chat, we can look at the users' questions, but I wanted to kind of sum up. And it's a little hard to do because this was 164 pages of deep, deep substance. So you see my 4 big, now what, so what's. The FTC, and I don't mean this critically, but what it is proposing is some extra friction in the parental consent process, especially for disclosures. Now, those of you who are engaged globally are used to layered consents or more granular consents. And what the agency is saying here is that you cannot put together all of your uses and your disclosure practices in one notice, get manifestation by the parent to consent in one bundle, and move on to engagement with the child. You have to separate out your disclosures and get a separate manifestation of consent for those. Another big picture bucket is that the FTC, and I had said this before, is looking for some way to use COPPA to affect user engagement techniques. We've all heard the terms dark patterns. We've seen law enforcement surrounding dark patterns. We have seen deep, deep concern about children's engagement online, hyper engagement, the use of algorithms to keep people engaged longer, and the FTC is exploring how COPPA could be used to address some of those areas of concern. If these, next big bullet, if these changes go into effect, I think all operators are going to have to take a deep look at their information privacy and security teams and think through bolstering those operations. There are a lot of obligations that will be imposed here, both on how you describe what you do and what you do at base. And you really are going to have to pay a lot of attention here. And these are areas that substantively have always been part of COPPA, but I think have been criticized as not getting as deep attention, even as the FTC developed a very robust privacy and security enforcement program outside of COPPA. And I've thrown an extra one in for good measure if you're not already thinking, how are we going to do this? There are some obligations that the FTC is proposing here that, in my mind, could expose operators to extra claims of deception. I find it curious that the FTC would require statements about compliance. At its simplest, we do not use identifiers in the following ways, and we comply with COPPA in the following ways. So this is an area of a lot of interest, I would expect, and something new for us to think about. The FTC is taking comment until March 11th. We know a lot of you are developing comments now. It will review those public comments for how long? That's an open question. It could issue a supplemental notice of proposed rulemaking, especially if it decides to turn into regulatory language some of the questions they've included at the back end of their notice of proposed rulemaking issued in December. And so maybe a final rule will come out this year. It will likely not be until later this year. And I've asked a question, effective date 2025, maybe. So we'll see. But the first deadline is March 11th to get your comments in. Well, we'll say thank you, but we're not ending yet because Lisa, what do you have in the chat that we can answer in our time remaining?
Thanks, Phyllis. That was incredibly thorough, and I learned a lot, as I always do from you. There is one question that I think is one that we hear all the time. So I will pose it to you, and then I have a couple of others that were prompted in my brain as you were speaking. Question about whether the personal information provided by parents about their children is included in the COPPA restrictions, or is the concern only about information obtained directly from the child?
It is the latter. It is information obtained directly from the child. And so COPPA has always, by its structure, been collected from, not collected about. That said, there is a catch-all category in COPPA that where you collect identifiers that may not themselves be defined to be personal, and you compile them with and append them to an item of personal information as defined under the regulation, all of a sudden that broader packet of information is personal. And so this combination question really does come up quite a bit when we work with operators in thinking through their information collection and retention practices. Interestingly, though, the information that can be collected from a child doesn't only have to be about that child. And this is where it gets a little kind of complicated. It can also be about a parent, but it has to be collected from the child.
Thank you very much. Let me ask another question that just came in. Oh, before I do that, so the slides should be in the chat. Somebody asked about the slides. They should be listed there. And to the person who asked about the COPPA requirements slide, that's in the chat as well. You'll see that in the slides. So question for you, what are the differences, if any, between the FTC's proposal and the proposed COPPA 2.0 legislation in Congress? High level, I know.
Funny that you asked. No, I have it right here. I printed it out in paper.
Let's do it.
What are the differences?
Okay, and then Phyllis, also, would the COPPA, the FTC's COPPA update then be overruled by any new legislation?
Okay, so yes and yes. Okay, so it's very interesting because it's clear that the COPPA 2.0 proposal that was issued last week took into account what the FTC issued in December. So now we're going in a very interesting legislative and regulatory circle. So this concept of user engagement has made its way into the COPPA 2.0 version. The bill, however, would ban outright what they're calling it. They're not calling it behaviorally targeted advertising. They're calling it something else. It will come back to me in a sec. But it would be individual specific advertising, and that is being banned. It would expand COPPA's reach to children under the age of 17. So it defines child as under 13 and then teens as under 17. It would change the knowledge standard. I know that was being discussed. And so I will grab what the knowledge standard is. It is some form of constructive knowledge with some color being given to that in the language. Let's see. It is actual knowledge or knowledge fairly implied on the basis of objective circumstances that the user is a child or a teen. Those are the biggies. But this is an effort that has been underway for a number of years. Senators Markey and Cassidy have been working diligently on this. I am looking at a press release right here. If you guys see me kind of looking down, they now have an expanded number of sponsors. Senators Cantwell and Cruz are on the bill too. And it's moving along with a bit more momentum than we've seen in the past.
Thank you. It's, it hopefully will be, at least there'll be some interest in privacy from Congress. I mean, there's been a lot of interest. It's just that nothing has moved. And, here we are now with now 15 state comprehensive privacy laws and no federal activity to preempt what is a melange of distinct requirements. And Phyllis, we're seeing this on...
Speaking of preemption, I just note that COPPA 2.0 would preempt conflicting initiatives by state only to the extent a state law or rule or regulation conflicts with COPPA 2.0, and specifically, nothing would prohibit a state from enacting a law that provides greater protection to children or teens.
Which could land us in the soup again. Right?
Well, speak of soup, on the same day, COSA there was an update and an upgrade to COSA, which now has 60 plus co-sponsors. So on February 15th, we got a COPPA 2.0 announcement and a COSA update too. So there is activity happening.
There is activity. That's helpful. And we have, and if I could ask you about this, we have so much activity on the state side, much of which has now been stayed. Could you give us a quick overview of what's going on the state side? And we can do a whole webinar on that separately.
Actually, I would say let's do that. There have been a lot of initiatives. There are initiatives that are aimed at incorporating age-appropriate design codes, like what was enacted in California. There are social media restriction laws, some of which would ban children's access to social media altogether. Others, or in some instances, particular forms of social media. Other state laws would require parental consent for an older group. And that's not what COPPA 2.0 does, by the way. The consent is not parental consent to the older group, but in some state actions, you would have parental consent requirements for an older group. And so there's a lot of movement at the state level. Now, there have been lawsuits that have challenged on First Amendment grounds primarily many of the state initiatives. And so, Lisa, as you said, they have been stayed, I think now 4 times. And so some of the laws are temporarily stayed while the state AGs defend those laws up through the courts. I know the first one to move to the appellate stage is the age-appropriate design code in California, but we've seen some success by groups challenging those laws across the country.
And I'm going to ask you one final question, and
Sure.
it's a loaded question because I know the answer, but I would love your commentary on it. Is to what extent has the UK age-appropriate design code influenced bills and laws in this country?
I think to a great extent, and I think possibly lawmakers would have come to this on their own. But I think it was hugely accelerated. Now, of course, there are fewer barriers to enactment of something like that in a country that has different, um, well, that doesn't have constitutional constraints. And so, it was easier in the UK, but they're a number of years ahead in terms of research and exploration of things like age verification and design techniques, and have engaged with industry there. So there are a lot of learnings, I think, that have come out of the UK. It's not an experiment anymore. It's deep into play, and that informed, at the very least, what happened in California with the California Age Appropriate Design Code. But there has long been some dissatisfaction with COPPA's structure. As I said, it was criticized for a long time as being a notice and consent structure that may have been outdated or of a different time. The age cutoff, which was hotly debated in those quick 4 months before COPPA was enacted, may have been viewed as too low. The actual knowledge standard may have been viewed as too high. So I think there have been opportunities for other approaches to be introduced and to flourish in the US, but certainly accelerated by the very groups who introduced the UK Age Appropriate Design Code. They've come and they've been met with a lot of excitement and interest.
Thank you so much. There is so much to watch in this arena, and we're going to look to you for guidance, because having that retrospective historical look is critical to understand the path forward. So we so appreciate your navigating these murky waters for us.
Oh, it's my pleasure. I would really encourage everybody. It is important to be heard, right? We're in an election year, but also it's, file, because it is one thing to be concerned about changes. It is another thing to weigh in on optimal regulatory language. And I will say, having been the part of a team who read those comments the last time, the more concrete, the better. And there's no shame in filing. There's just a lot of utility in doing so.
Thank you so much, Phyllis. I would invite participants in our webinar to visit our privacy blog at www.huntonprivacyblog.com. It contains the latest developments on privacy and cybersecurity globally, and we look forward to having you at future events. Thanks for joining us.
Thank you, everybody.